All those please go on and do attention, you shall be heard. We got to save these United States, the great state of Florida.
Please be seated. We're starting with Interstate Fire and Casualty Company against Tatiana Abernathy and others. Is counsel ready to proceed?
Yes, sir, Your Honor, I am. Your Honor, good morning. Happy Valentine's Day. I'm Catherine Giddings, and I'm here today with Larry Matthews on behalf of our client, Interstate Fire and Casualty Company, and I would like to reserve 5 minutes for rebuttal. Your Honors, this entire case turns on whether this certificate of insurance that was issued for...
Isn't the logical import of as required by written contract a written contract between Emerald and the person who's seeking to be the additional insurer? I mean, why isn't that the only thing that could mean?
Well, because it says as required by written contract. What contract? Doesn't say what contract.
Well, the certificate of insurance, or the disclaimer language is pretty specific, and I'm concerned that we cannot ignore that it states specifically it's a matter of information only and confers no rights upon the certificate holder.
We went through that under Florida law. Clearly, we went through that with the trial court extensively. We argued that issue. It was thought out. The typewritten provisions in a contract trump the printed provisions. That's basic Florida contract law. When Wardlow, as agent of Interstate, inserted Touchdown Club is named as an additional insured, but only insofar as the operations under this contract are concerned. So this contract, as required by written contract, satisfies the policy.
And who are the parties to the, you say the certificate of insurance is itself a written contract?
That's correct.
And who are the parties to that contract?
Choctaw Club and the Interstate Fire and Casualty.
And the Choctaw Club sign it?
I'm sorry, Your Honor.
Who signed that thing, that certificate
Dick
of insurance?
Wardlow signed it as with the authority of Interstate. Basically admitted in affidavit by John Carr, Dick Wardlow has the authority to issue certificates of insurance on behalf of Interstate Fire and Casualty Company. And
well, that's unusual language in a contract, right? That it confers no rights.
well, that's a printed provision in any certificate of insurance. It's just a printed form.
Well, that's what we're talking about, right? Certificate of insurance.
Yes, sir. It's just a printed form that says it confers no rights. It's a printed.
So it doesn't sound like a contract, does it? Confers no rights.
Well, except in the typewritten provision, it says Choctaw Touchdown Club is named as an additional insured, but only insofar as the operations under this contract are concerned.
What if the certificate of insurance had said, in addition to naming them as an additional insured, their coverage is $50 million? Your argument would be the same, that we now have a contract between the insurance company and Choctaw, and the coverage is now $1 million, or $50 million rather than $1 million, wouldn't it? I mean,
no, sir, Your Honor, with all due respect, that would change the terms of the policy. The policy is $1 million. So the certificate of insurance does not change the terms or conditions of the policy.
So if we disagree with you on that, the case is resolved in their favor.
As to that the certificate of insurance changes the terms of the policy?
Correct.
No, not necessarily, Your Honor. Because even if it does change the terms of the policy, and we pointed that out, if you consider that it does change the terms of the policy, that issue. Assuming that they were actually changed, the CEO at bar by its explicit terms as a written contract by and between Interstate and Touchdown Club. So it went on to describe that the insurer elected to use the all-encompassing general wording as required by a written contract, which unquestionably and unambiguously can mean as required by any written contract. So if I'm wanting to point to that one area that we addressed, your question. Even if you're correct in that assumption, and even in that assumption, if the policy permits modification of its terms and conditions as shown by the following provision, the first name insured shown in the declarations, Emerald Coast, is authorized to make changes in the terms and conditions of this policy with Interstate's consent. This policy terms can be amended or waived only by endorsements, i.e. the COI.
So then the answer to my question, if you're right about all that, then the answer to my question would be that Mr. Wardlow could have amended the policy to $50 million. I mean, if I understand your argument correctly, that the policy allows amendments, and so if the COI amended the policy, it's okay, then you would have to answer yes to my question. The COI could have upped the coverage to $50 million.
No, sir, it could not, because that would be a change in the terms and the conditions of the policy, not just amending it and adding the Touchdown Club as additional insured, which the policy, Emerald Coast paid for additional insured coverage under that policy. So to change absolutely change the policy and to increase the limits of the policy.
Could they have added, could Mr. Wardlow have added his brother-in-law, even though Emerald and his brother-in-law had never done business? Could he just say, I want to add this additional insured? I mean, it sounds like under your interpretation of the policy, although as long as they don't change the amount of the policy, they can add as many additional insured no matter if they had a relationship or not. Am I misunderstanding?
If his brother-in-law was in fact associated with the Touchdown Club and was involved in the incident.
Okay.
All right, thank you, Mr. Powell.
Thank you.
Your Honors, their argument is that the Wardlow was the agent for Interstate, but their argument is also that Wardlow was the agent for the insured in procuring insurance. Then their argument is that the certificate of insurance, despite the explicit disclaimer language, conferred coverage and was a new contract. So under their own argument, Wardlow could not have been the agent.
How do you respond to their argument that the definitional or the provisions that talk about a written contract that requires you to maintain insurance and to include such a person as an additional insured speaks to something other than what we're here talking about today?
Well, Your Honor, numerous well-established case law states that although an insurance contract is to be insured in favor of the insured when there is an ambiguity, though such construction must be reasonable. The additional insured states who is named as an additional insured under this contract. It says as required by written contract. The COI didn't require anything. It has to be talking about a written contract between Emerald Coast and the Touchdown Club requiring insurance. And opposing counsel conceded that at the very first hearing in this case and that was when they came up with the argument later that the COI was a freestanding contract on its face that conferred new coverage on the Touchdown Club as an additional insured.
Right, but I guess I understand that argument clearly. But there's a provision of the contract, and I was looking at an insurance contract, 146 of the record, that more explicitly states
what the written contract is.
Well, written contract that requires you to maintain insurance and to include such person as an additional insured. Their argument, as I understood it, was that language relates to an other insurance clause, not to this particular provision. Is
Your Honor, that is one place where it discusses what the written contract is, and it says as required by, and it's going the next step and saying if the written contract requires insurance and there's additional insurance, and that additional insurance is going to be primary, that there are numerous cases. The policy is in this record a lot, and so my record sites are a little bit different than yours, but if you look at the exclusions, on page 1039, it says the policy doesn't apply except to an insured contract, and it talks about, and who is an insured on page 1045. Under the definitions, under subsection F, it talks about a contract that is insured as an additional insured. Is that part of any other contract or agreement pertaining to your business under which you assume the tort liability of another party? I mean, it's throughout the contract talking about, and if the certificate of insurance could be the written contract, it reads out of the named insured as required by, and it renders it meaningless.
So the certificate of insurance under Florida law, though, is a part of the policy.
Your Honor, it states that it is part of the policy. It can be. You have to read it all together. But there are lots of different types of certificates, and our position is not that all certificates of insurance are for information only. There are two types of certificates. One is a certificate that actually gives insurance. The other is one that on its face says it's for information only. In this case, the explicit disclaimer tells the insured that this is not a contract, this is not vesting any rights in you, and the policy is going to control. So if there's any question, they are on specific notice that they need to check that policy.
All right, I think we have your position, Mrs. Giddings.
All right,
Thank
Your
you.
Honors. And just in closing, no coverage exists because there was no written contract. The certificate was issued after the accident, and the COI is not a contract on its face. And in addition...
Thank you again, Mrs. Giddings.
All right, thank you, Your Honor.
All right, call now Lance Block, PA, against Searcy, Denny, Scarola, Barnhart, and Shipley, PA, and Corcoran and Associates.